Today we're going to talk about the genuineness of assent. We're talking about specifically is the effect of mistakes, the effect of misrepresentation and fraud, the effect of duress and undue influence upon contracts and their enforcement. Mistake, basically the rule is a mutual mistake invalidates a contract, except where the mistake is a mistake of law, when it does not actually validate the contract, because we're all presumed to know what the law is. So that's one thing. And the other thing is to keep in mind that a unilateral mistake does not invalidate a contract. So let's take a look at some examples here. Example 1. This is a very famous old case called the Peerless case, involving two ships with the name Peerless. And what it was the buyer was to receive 1,000 bales of cotton for $100,000 delivered from a ship called Peerless, bound from Bombay to Liverpool. And so this was in the early 1800s, so it was common law of England. Common law of England was still recognized by the colonies even after the Revolution as being part of their law. So it's been cited by many courts in this country. On October the 9th, a ship Peerless arrived on the Liverpool dock. Therefore, the buyer, thinking that that might have his shipment on it, went down to and contacted the ship's captain, and he found out that in fact there was no cotton on there owned by the seller. It had no cotton owned by the seller. So the buyer thought, oh well, I'll just cancel the contract, which of course is an option that you have when somebody doesn't fulfill their obligation. And in this case, the obligation to deliver goods was not met. He can cancel the contract, so he walks away. Then later, on October the 19th, so on the 9th, 10 days later, another ship, which also had the name Peerless, arrived, and it had come from Bombay, and it had the cotton that the seller had agreed to sell to the buyer. And the buyer, however, refused to take the cotton, say, well, you know, you breached the contract and I canceled it. Of course, the problem here is that there was a mistake. Both of the parties were mistaken as to when the ship would arrive. You know, both of them thought that the cotton would be delivered when the ship Peerless arrived, but neither one of them knew that there were two ship Peerless actually bound from the same port to Liverpool, arriving close in time, but later. And so the seller sues the buyer, who refuses to honor the contract. What happens? Well, since there's a mutual mistake of fact, the court, said, well, there was no contract. You didn't have a mutual understanding to begin with. The buyer wins because of the mutual mistake. So that's one case. Okay. Another example, we're going to talk about a case involving a change in zoning laws. When you have a change in zoning laws, one of the things that can happen is that if you have a non-conforming use, so in zoning law, non-conforming use is a use forbidden by the new zoning laws. If there's a non-conforming use, whatever is actually active at the time cannot be taken from whoever owns it. So it's a property right, right? So actually, in this case, Seller Smith had sold most of his farmland to a developer who incorporated it into a small city named Park Hills. Smith retained his farmhouse, which was included within the boundary of the new city, therefore subject to the zoning laws. Smith was a little bit worried, so he was asking the developer, and the developer told him that his chickens and his coop for the chickens could remain on his property. So he kept a small piece of property, and in his backyard he had this chicken coop, and he raised chickens. And he was told he could continue to do it, that it would be grandfathered in, that's what we call it, when a non-conforming use is allowed to continue. And buyer Brown was told by Smith, so when he went to sell the property, Buyer Brown was told by Smith that after he became owner, he could also continue to raise the chickens. He says, I've been raising these chickens for years, and I've been here for 20 years, and subject to the zoning laws, and they've never interfered with me. You could continue to do the same thing because it's grandfathered in. this was a mistake of law. After he became the owner, his neighbors complained about the chickens. So maybe they understood the law, and his lawyers explained that the chickens were a non-conforming use, which in this case was no longer grandfathered in. So that exception to the zoning law doesn't apply when the use is discontinued, and it's considered to be a discontinued use. If you sell the property on which the chickens are being raised, you are no longer owning chickens on that property. You're grandfathered in, but your subsequent buyers are not grandfathered in. And therefore, the contract stood. It's not a mutual mistake. It's a mistake. It is a mutual mistake, but it's a mutual mistake that has basically a mistaken conception of the law. You know, but maybe both the parties don't understand what the law is. That doesn't do it. If you're mistaken on the law, you're not going to get the ability to avoid the contract that way. So. Fraudulent misrepresentation, elements of fraud. There are several elements of fraud. The first one we'll talk about is misrepresentation of a material fact. It's an intent to deceive and thereby induce or cause another person to enter a contract. So that's the second thing. So the first thing is you have to have misrepresentation of a material fact. That's not just any fact. It's a fact that would really change the mind, perhaps, of somebody who's entering into a contract. If he knew what the fact was, that would be a material fact. So for instance, if you knew the car was rusty, that might change your mind. If you knew the car had a lot more mileage than is what is showing on the speedometer, that would change your mind as to buying the car. So a material fact is one that makes a difference to the parties. You know, maybe making the price higher, or making it something perhaps that the buyer wouldn't want to buy in any case. So now you can't just have a misrepresentation of material fact and get out of the contract and avoid the contract on that. You also have to show an intent to deceive and thereby induce or cause another to enter into a contract. So there has to be this intent to deceive, and we call this inducement. So you know, you have to be inducing the party to enter the contract. You're causing him to get in there, and we call that inducement. So an intent to deceive and thereby induce or cause another party to enter into a contract that he might not otherwise enter into if he knew the true facts. A third element is the victim must justifiably or reasonably rely. Some people talk about justifiable reliance and talk about reasonable reliance. What is that? That is basically, it has to be something that is credible to the victim. He must believe it, and you know, he shouldn't be too credulous. He shouldn't be unreasonable in assessing whether or not this is reasonable to think that this would actually be the case. And so he's expected to have a little bit of common sense in terms of what the statements were made, the statements that were made, whether or not these things would actually be likely or not becomes an issue as to whether or not he was justified in relying upon it. Is there some reason that he could observe that the facts are not as the buyer says? So, for instance, if you're buying a house and you ask the seller, oh, well, do you have a problem with the roof leaking? And the buyer says, no problem with the roof leaking, but you can see that there is water stains on the ceiling. It might not be reasonable for you to rely upon that. Of course, you can have an inspection done, and you know, you could ask him, well, did it ever leak? And if he says no, it never leaked, it just doesn't sound like that's something you would reasonably be relying upon. Okay, upon the misrepresentation, when the victim agreed to the contract. So one of the things you want to do when you're buying a good, or you're buying real estate, or you're buying anything that can be inspected, is inspected to the extent that you can do so. Because you will be expected to have to prove that you were reasonable when you relied upon statements that were made, or you just relied upon something being in good order, because typically things are. The car seems to be running well, and you get a statement that is in tip-top condition, and you ask them, well, have you changed the shocks? It's got over 100,000 miles, and he says yes. Well, you're not going to take the car apart. You don't need to take apart the car to find out, but you can go for a ride in the car. And arguably, if it's a bumpy ride, arguably that should have put you on notice that that might not in fact be the case. But I think that you might have a good case still to argue that you should be able to reasonably rely upon him saying that the shocks had been replaced. And if he shows you a receipt, what can you say? So all of these elements, all three of the elements must be proven to establish fraud. Now, that's to establish the existence of fraud. And of course, you can use the existence of fraud to avoid the contract entirely. Cancel it. And you would actually, if you actually wanted damages, you would have to prove what your damages are. And so that's where we got into remedies. With the sale of goods, it's actually going to usually be the difference in price. And in some cases, there may be some other element to it in regard to harm that was caused. There certainly can be harm caused if you bought something and you didn't know the true facts, and therefore you used it in a dangerous way, or it cast you in a light that you didn't really want to be in. All of the above must be proven to establish fraud. First example. Now remember, all the elements have to be proven. So let's see. This is a case, I was watching Seinfeld, and you all know George. George's really kind of a naive guy in some ways. Anyway, George is out looking for a car. He's talked to a salesman about a certain car, and he's going back to get a candy bar out of a machine down a hallway, and he's passing the office of the car salesman he'd just been talking to. And he overhears the car salesman, who is not looking at him, probably doesn't know that George was there, telling someone that John Voight, the owner of the car that, and he identifies the car, the owner of the car that George had been looking at, was saying that John Voight needed to do something, that he was the owner of the car. Now, John Voight, I don't know if you know this, was a famous actor. He was nominated for an Academy Award for his role in Midnight Cowboy, and had a number of famous movies. So George got the idea that this was a celebrity car, and of course celebrity cars are valuable. And the price that was being asked for was certainly not the kind of price that George thought it should be getting as a celebrity car. So he rushed in, and he immediately bought the car, snapped it up quickly. Now, was there fraud when it turned out that it wasn't John Voight, the actor, but another John Voight, spells his name even differently? Was it fraud? There's no indication that the salesman knew he was being overheard by George. Therefore, he was not inducing George. He was not causing George to enter the contract. He had no intention of doing that. So he has to have the intent to induce. And so you have to have all the elements. If you don't have that element, then if you don't have the element of justified reliance, then you don't have fraud. You might have an innocent misrepresentation, which we'll talk about later. Let's take a look at another case. Whoops. I gotta go back. Okay, this is the second example. Gotta put my glasses on now. This is example. In August, Sully put his house up for sale, but before doing so, he painted over watermarks in the ceiling where the roof had leaked. The buyer, Mr. Banks, was not informed of the leaks. His inspector also failed to discover it. Inspectors are usually very good about these kind of things and can spot things, but this time he did not. When the house leaked a month later, after he bought it, Banks called the inspector, who went into the attic and found that the leak was caused by overly long nails used to secure insulation to the roof that pierced the shingles. And he found out that those nails had been put in there over a year ago. and therefore they were causing the leaks, just little tiny leaks that were coming through the holes in the shingles that the nail caused. That can happen when you're putting very close insulation up into the ceiling. So there's insulation that you can put right up on top of the roof, and you have to nail that into the rafters. But if you nail it into a spot where the rafters or the wood that you're nailing into is not very thick, and you get too long a nail, you're going to pierce the thing. And it's not something that's easily found by ordinary inspection. You have to maybe go up on the roof and lift up the tiles where there's a leak to find that where these little holes are in it. Anyway, so this is understandable why the inspector would not necessarily have caught that. But of course, when he went into the attic, you could see that there was quite a bit of evidence that there had been leakage. And when he figured out what it was, he could figure that, well, when was this actually done? You know, when was this roof actually pierced? And so they could get that information. So Mr. Banks knew that it was there. So he would have a case, right? He would be able to establish a case for Sully's misconduct. His intentional covering over the watermarks was obviously done to induce buyers into buying the house. He waited till August because August was a month in which you do not get a lot of rain. I don't know, maybe he put, in anticipation of it, he might have put buckets up there to catch water if it did rain. Anyway, however, he somehow arranged for it. So Banks went to file a criminal complaint against Sully because, you know, a criminal complaint theoretically could be brought. Prosecutors, however, will not pursue a case of ordinary fraud where the seller can't file his own private lawsuit. So I've actually had a friend of mine wanted me to sue somebody on a similar fraud case, not exactly like this. But, you know, I told him, I said, the prosecutors won't do it. Even though I had a personal friend at the prosecutor's office, I went down and asked him, can I file this case? And he said, no. I said, oh, that's what I told my client. I said, we cannot file this as a complaint. You will not prosecute this. He said, no, in these kind of cases, you know, you've got a right to bring your own suit and tort, and you should pursue that remedy. And so that's what we did. Anyway, so I just wanted you to know that you can't necessarily use the prosecutors to build your case for you. In some cases it might happen, such as in the O.J. Simpson case. I imagine that the later civil prosecution, the civil case brought against O.J. was helped by the fact that all the evidence had been dug up that could possibly have been dug up by the criminal prosecution. And in fact, they were able to test various theories, weren't they, about how to prove it. And since the civil case is a much easier case to bring, you only have to prove that it's more probable than not, rather than proving that it's beyond a reasonable doubt. You can oftentimes then win the civil case, and you will have a great benefit having a professional team of investigators, the police, going out and gathering evidence for you. But they're not going to do that for you on ordinary kind of cases like that. They'll say, well, you should bring your own case. And so that's that. So that's an undisclosed defect. So basically, there are acts now, and most states have acts that are called real estate sales disclosure acts. And there are case decisions even before these acts, even before these statutes were passed, in which the common law courts, the state courts, the courts acting in the tradition of common law had changed the actual rules and didn't require a active misrepresentation, but you know, a failure to do something, a failure not to disclose something, has been deemed to be something that is fraudulent by these state courts. But these acts make it clear that some of these things are in fact not to be approved of. So a majority of states have these disclosure acts. Non-disclosure states include Alaska, Idaho, Indiana, Kansas, Louisiana, Maine, and Mississippi. Okay, and so those would be states in which you cannot, you don't have a requirement maybe for real estate hazards to be disclosed. So In California, you know, you have the Civil Code Section 1103, which I'm going to talk about in the next slide. Okay, and so this is an example of one of these kinds of things. Other states have different statutes, and they maybe protect from different, maybe require different kinds of disclosures. There are some that are fairly common, but in the state of California, real estate sellers, you know, and that would include a person who's, you know, selling his own house, a for sale by owner house, would include the person, the owner is the seller, but it would also include real estate salespersons, but also real estate seller and the brokers who employ the salesmen are required to make sure that they disclose risk of various hazards. First one listed is a special flood hazard area. So if you're in an area that's subject to being flooded with some frequency. Then also, if you're in an area where there could be dam inundation, that is, there'd be water escaping from the dam, or maybe there is an overflow, and there is usually like a spillway that will allow water to escape rather than having too much water in the dam, which is dangerous. You'll oftentimes have a spillway. When the water gets to a certain level, the water will go down the spillway. Sometimes these create like what might be seen as holes in the lake. They look like a hole in the lake. And if you're swimming in a dam, you might not want to go too close to the dam's edge where the dam is actually located, because spillways are usually located fairly near them. Sometimes they're closer up, but it's also important maybe to be careful if you're going into a dam, to make sure, if you're swimming in a dam or going boating in a dam, to know the lake somewhat, to know the geography of the lake, because these spillways can be quite large. I mean, the spillway might be 20 inches across in diameter, and so 20 inches, I said, no, I meant 20 feet. Okay. So dam inundation is a second kind of problem that you would need to be warned about. Third, very high fire zone. So, you know, some areas of California, they have droughts from time to time, and they have risk of fires, and people wind up losing their houses and maybe even their lives. These things come up very quickly in a dry season. Wildland fire. So basically, that's very, very same. You know, it's also some. And then the fifth one is earthquake fault zone, because you know there is lots of earthquakes in California, and if you're in a fault zone, you know, it would probably maybe cause you not to buy a house, or maybe you wouldn't want to buy a house in a fault zone, or if you did, you would be willing to pay less. So that's a very material fact. A seismic hazard. Seismic hazards are related to, of course, these earthquakes things, and you know the hazards are also from structural buildings and highways, all of which can collapse, and so you need to be informed about whether there's a nearby hazard like that. So anyway, these are the ones that are listed, but also these supplemental hazards are also commonly accompanied in California by a disclosure of radon gas exposure. Radon gas exists in watery soil. If you have a lot of water under your property, if the land below has a lot of water, this radon gas can seep up even through your concrete and into your house, and will be trapped in your house and will build up. And it's believed to be a cause of cancer, especially in people who smoke cigarettes in the house. So one thing you might want to do if you are a smoker of cigarettes is not smoke inside houses. You also make little stains on the ceiling, so it teaches the value of the house, and maybe causes you to have to paint the roof before you sell it. But in this case, that would be painting it not because you have anything other than a yellow stain above your favorite chair where you like to sit and smoke. Anyway, so radon gas exposure is one of the things that's commonly reported, and also other states will maybe have a requirement that you disclose these radon gas existence. And so if you are buying a house, you can ask the inspector to check for radon gas. There's a test for it that can be done. There's a little kit that you buy, and they install it, and it tells them whether or not there is radon gas. Airport influence zone. What do we mean by airport influence zone? It's basically, airport influence zone is basically an area oftentimes that there's a nearby airport and the planes are passing overhead, and therefore they make a lot of noise and can be very disturbing for people. And so you might not want to be on the approach path to the airplane. There can also be, planes can also actually crash, you know, so there's a possibility of that happening. And in some cases it's worse than others. Some of it has to do with topography. So if you have a hilly area, there can be wind drafts that could cause certain planes maybe to lose their bearings or suddenly drop or suddenly lose their steerability, change their direction quickly because of these air drafts that come up. Planes are actually floating on air, right? So if the air, if you get up drafts of air or down drafts, it can affect airplanes coming into an airport in a very crucial time. And so there are some areas with some airport that they don't allow the airplane to travel over. But if sometimes they do nonetheless, so you might want to know about that. Also, another thing that is frequently, commonly reported, and may be required, I believe, by federal law to be reported, is Megan's Law disclosures. Megan's Law requires that the if there is living nearby a person who has been convicted of a sexual criminal offense, especially a case of child molestation. If there is a sexual criminal in the area, that has to be disclosed. And so Megan's Law disclosure. If you're buying a house, you might like that it has that. I mean, because basically you'll be looking to see whether there is a sexual criminal in the area. Or you may not want to buy into an area like that because you think it may cause you problems. And not necessarily because you have somebody in your family who is a child molester, but maybe perhaps that you think that it might cause the price to change one way or the other if something happens. So, if a neighbor's house gets bought and they have a child molester, suddenly everybody knows that, next to you is this child molester. Anyway, military ordnance. That is, are you next to an area which has high explosives? And so these are hazards that have to be disclosed by some states. In California, I don't think they're required according to this, but they are commonly reported anyway. And amongst real estate salespeople, there is oftentimes a conviction that it's better to disclose things. And because even if you don't disclose these things, like I said, the courts themselves might decide that there was a duty to disclose a hazard that's not maybe required by statute, but the court just decides that because courts can sometimes do that. And so I think that's one reason why the agents think it might be good to disclose that to people. And also, if in fact the community doesn't have any of these hazards, you probably would want to disclose that. And you'd want to be in a market, if you're selling those kinds of houses, where other people have houses that are in hazardous zones. You would want to be competing against those because you could probably get a better price for your house because you're not having to compete so hard against other areas that have these hazards. So anyway, that's the California Act, and other states have other acts. Lynch versus George Savage. Defendants specifically knew that the building was in disrepair, and units contained therein were illegal and placed for a condemnation. So this is another example of fraud. Here you show that basically you're meeting an element here, or partially meeting an element here. The defendant knew that the building was in disrepair, and the units contained therein were illegal and placed for condemnation. Now, it would be clearly fraud if he were to tell somebody that it was in fact in good condition, but if he makes no misrepresentation, this case is going to deal with that. If he doesn't disclose this. So defendants willfully and fraudulently failed to reveal said information to others. They didn't disclose the fact that the building was in disrepair and contained, not only that, contained illegal structures in place and was placed for condemnation. Okay. Defendants knew that plaintiffs relied on their non-disclosure and intended that they should so rely. So, they were counting on them. And is it reasonable for them to rely? Is there an obligation for them to inspect? Of course there is an obligation to inspect. How far does that go? How far do they have to go in inspecting it? If they hire an inspector to come in and he inspects the place, is he going to spot all the things that may be wrong? Will he know that what the structure is partially illegal? He may not know. Maybe he'd have to go down to some public office and look through the records to find out whether or not there had been a condemnation proceeding. And so there's a little bit of an issue here as to whether or not they were justified in relying upon this, the non-disclosure. So, like I said, there was no affirmative statement by the defendants as to the condition of the building. But they did know that they were relying on it. Said non-disclosure was in fact, in law, misrepresentation of a material fact. So they pointed to California law indicating that this is something that should have been revealed. I think this was actually a Wisconsin case, so there's a statute in Wisconsin. Anyway, so the actual market value of the property was $5,000 less than what it would be had the condition be as was represented. Now remember, it wasn't an active representation, it was sort of a non-disclosure representation. They didn't say it was bad, they didn't say it was good. The complaint sought $5,000 in general and $10,000 in punitive damages. And so you can see that oftentimes the law only covers things, the letter of the law oftentimes need to be interpreted. So, I mean, you got to interpret. The law may say, in fact, that you have to have justifiable reliance, but what does that actually mean in a specific case with the facts? And so, ideally, there were previous cases that would have disclosed how to do this. And so, if you read the decision of the court, they list all these cases. Now, I didn't read all the cases because it was like a old paragraph. It must have been 20 cases in there where they talked about these issues. And the cases are all different. You can't just look at one and say, oh, okay, this is just like this one, because it's not likely to be exactly like that. But it's going to be a case in which it was the justifiable reliance was actually interpreted. So, so in this case, actually, the plaintiff won. The court found that there was a duty to disclose and that it was wrongful for that and that it was fraud for the seller not to have disclosed these very serious facts that, in fact, the place had already been condemned. So, like I said, there are, statutes on that. There are also court cases on that. In Indiana, you might have a case that somebody didn't disclose a basement leaking, and that was found to be in that particular, under those particular facts, in that case maybe to be a case where he should have disclosed. And of course now, if you in fact cover it up, if you, let's say that you have a leaky basement, and so you, before buyers come, you always make sure that you clean up any indication of the leakage in the basement. If you're actively covering it up, that is more easily found to be a case where you should be disclosing, a case where you have actually fostered fraud. Like, and for example, it also is painting over the marks on the ceiling. I mean, that's you'll find that state courts will frequently find these to be a misrepresentation when what you have is a non-disclosure. But it's not merely a non-disclosure. There's also some active covering up. So there's a cover-up of the thing to prevent somebody from discovering it by an inspection. This all goes back to a case in England where a man who had a very old mule basically shaved the mule down, cut down a lot of his hair, and actually filed his teeth down, because people who were buying horses and mule would look at the length of the teeth of the horse to determine how old he was. So this fellow filed the teeth down on the mule. It was an old mule. He wanted to get rid of it because he wouldn't be able to use it maybe for too long. He wanted to get rid of it, so he wanted a good price. So he made it look to be a younger mule, and that was found to be fraud. Even though he didn't make any representation as to the age of the mule. When the buyer asked him, how old is this mule? He said, well, I don't know. Look for yourself. Okay, figuring that he would be deceived, and he was, and therefore that was found to be fraudulent in England. So you have these kind of things. Now we're going to talk about non-fraudulent misrepresentation. So this is innocent misrepresentation. Most jurisdictions allow for rescission in these cases. So we're talking about rescission, we're talking about canceling the contract, we're talking about avoiding the contract. In some cases, that's the case. Then you will have something also called negligent misrepresentation. If the negligent party has a duty to know or reasonably should have known, then it will be treated as a fraudulent misrepresentation. So you find this in lots of cases. You know, maybe there's a duty when you're selling something to disclose facts. If you're selling a company, maybe you have a duty to disclose the true facts that you've been misrepresenting the income of the company before you sell it. So you maybe haven't yet filed the correction that you need to file when you misrepresent income for 1 year. And you know, you should, after, when you discover that that's in fact been the case, if it's a material misrepresentation, which would be the kind of misrepresentation that leads to a fraud case, you should actually report that in your accounts. And if you know about the fact that you have misrepresented things and you're selling it, and yet you haven't actually got it on your books yet, you probably need to disclose that we are going to be restating our income for this period of time. So negligent misrepresentation like that can be found to be fraudulent and even subject you in some cases, if it's seen as being serious enough, to actual prosecution under criminal fraud statutes. So normally you don't find that, but if we're talking about a lot of money and a lot of people being defrauded, a lot of stockholders being cheated, you could be talking about a case where the law decides to proceed criminally against the party making the misrepresentation. And so also maybe punitive damages might be available for a negligent misrepresentation. So a negligent misrepresentation is different than an innocent misrepresentation. Innocent misrepresentation, there was no duty to disclose. There's a duty to disclose the financial condition of the firm when you know that the books are not representing that. And you know, it might have been a innocent misrepresentation if you didn't know of it, but once you have known it, you need to disclose it. Okay. So if the negligent party had a duty to know or reasonably should have known, that's the standard. The question is, did he have a duty to know? And nowadays, under Sarbanes-Oxley Act, the CEO and the CFO have the duty to know. And I think that was put into Sarbanes-Oxley purposely to allow, or to bring home the seriousness so that no executive wants to get sued and found to have been committing fraud. And you could, I could say, go to jail on something like that because it's going to catch headlines, and so it would be something you would want to stay away from. So let's go on to the next slide here. Duress. Any wrongful threat which overcomes the will of the victim was duress. Now, at common law, the threat had to be a threat of violence to a person, or the threat to burn down a dwelling house would qualify. That is, the threat to burn down your home, burn down your apartment where you live. You know, if you had a store, a threat to burn down your store would not be seen necessarily as duress at common law. This has changed. It was obviously wrongful for anybody to make that kind of threat. And so any threat that's wrongful is found by a jury or a judge to be wrongful if the case is tried to the judge which can happen if both sides waive a jury. So basically nowadays, any wrongful threat which overcomes the will of the victim. So the question is whether or not this victim was seen as vulnerable to this kind of threat. Were they the kind of person who would be affected by this kind of threat so much that they would do something that they otherwise would contract, maybe make a payment or enter into a contract, which they wouldn't have done had it not been for the threat. And so it need not be a threat of violence. The test is whether the will of this victim was overcome. It is not an objective test. That is, it's a subjective test. You're looking at this particular defendant, and a jury can be instructed that they should look at this particular person, that they shouldn't think of whether or not they would be doing what this victim did in entering the contract. They should think, well, this victim, being in their circumstances, the way they are, being who they are, and being under the circumstances that they exist in, would they likely do it? So it's a very subjective test rather than an objective test. So oftentimes in law, we have this idea that law is going to be objective. Well, for the most part, it is, because we do have a general idea that people are in control of their own fate, and therefore and have control of themselves, and therefore we oftentimes look at things in a very objective way. And that means that oftentimes we will look at something and say, well, what would I have done in that situation? If we find that, well, what the person did doesn't seem reasonable from my point of view, we might think that they're not being reasonable, and we'd say we're being objective. We would think anybody in that situation would not have done that. In this case, the person maybe entered into a contract or paid money when you say, well, I would never have done that just because they threatened that. Obviously, you would threaten, you might give in to somebody threatening you with violence or burning down your home or even burning down your store. Okay, so some threats are more serious than others. But this is a case that I'm going to talk about here. I'm coming up with a case. So a threat to file criminal charges is wrongful regardless of their soundness. So whether a person could actually bring criminal charges or not is going to be seen as duress if he entered into a contract because you threatened him with bringing criminal charges. That's blackmail. Okay. And of course, you can be prosecuted for blackmail. So I don't advise you doing that to gain an advantage in a contract. And also, once it comes out, once it's proven, that contract's not going to be worth the paper it's written on. And so a threat to file criminal charges is always wrongful. However, a threat to bring a civil prosecution is not wrongful regardless of its soundness, even if, in fact, the guy doesn't have a case to bring a fraud case against you. So he's alleging that you're trying to commit fraud or you have committed fraud. Now that's an interesting thing because fraud can be brought, could be a criminal case or it could be a civil case. You would probably want to clarify, you mean you're going to talk to a prosecutor to have me prosecuted? And clarify, is he meaning to threaten you with criminal prosecution, in which case you know that you're under duress then. If you sign, you could always bring that up as a way of getting out of the contract. I don't recommend that you sign with this person. If they're willing to make threats like that, then what else they might do, I recommend you steer clear of such persons. And so not deal with them at all. And now, if he says no, that he means to bring a civil case against you, if he says, I'm going to have my lawyer sue you for fraud, he's talking then about a civil case, he's not talking about a criminal case. And you do not have wrongful behavior there. Okay. I got this case I'm going to talk about. Okay, in this example, there are these two sisters. Their dad died, father died, leaving the entire estate to the younger sister. We'll call her Ethel. Okay. The older sister demanded half the estate. Call her Maleficence, how that? Make her a villain. Older sister demanded half the estate, threatening to reveal to society if she wasn't given the money, she wasn't given half the money, to reveal to society that she had had an incestuous relationship with the father. And that the younger sister was overcome with the fear of the disgrace, because she was held in high regard by society, went to all the society dances, saw herself as moving up in the world, hoped to marry well, and that kind of thing. Anyway, the younger sister was overcome with fear. In this case, the threat is wrongful, although it clearly would not have been under common law. And maybe for a lot of us, we'd say, well, I wouldn't give half of $100,000 to somebody because of a threat like that. I wouldn't give half of $10,000 to somebody because of a threat like that. Therefore, the duress was present, and she can avoid the contract. And she actually did that. After the older sister left with a check for the money written by the sister called up the bank and stopped payment, and then she fought her in court. Of course, also, there might have been other actions she could have brought against her, but anyway, so duress was present in that case. So these are ways of getting out of contracts, like I said. So we talked about misrepresentation, we talked about mistake, we talked about duress. We have one further, economic duress. Well, we didn't talk about economic duress. Okay, economic duress. Hard bargaining is not in itself duress, so you can bargain hard. However, sometimes people go beyond the pale. They go beyond where they should, and duress, and sometimes hard bargaining can become duress. However, in cases where there is a threat to, in bad faith, breach the contract, okay, which could precipitate a business failure, then bad faith supplies a wrongful aspect. So basically, a deal in which the acquiring store was buying up a smaller clothing store to add to its stores was found to be involving economic duress, because they were, under the terms of the contract, required to hire the executives and pay them for a period of time, and actually pay them a severance pay when they left. And these things they didn't want to pay, and they said, unless you give up these perks of the sale, we're going to pull out, because they discovered that the firm was maybe not in as good a condition as they thought it had been. That may actually brings up the question of whether or not they had been defrauded, but we'll leave that aside. In this case, they want to go through with the deal because they got them to give up their rights to do that. And these executives in these firms decided to nonetheless sue for economic duress, and won, because the threat to pull out the money would have precipitated a bankruptcy of that small store, and that would have meant that the other sides would be relieved from the obligation to buy the smaller clothing store. And so that was found to be wrongful in that case. Like I say, a lot of these things will require an interpretation of the facts in the case, even though you have the words of a statute. How those words are applied, so oftentimes the law is not simply a matter of principles, but it's principles plus the application of principles and their application to the facts and individual cases. That's why case precedents are so important in our legal system. Undue influence, that's the last one. Now, the elements of this is a susceptible victim. Oftentimes that might be an older victim, but it's somebody who's susceptible maybe because of illness or youth even, maybe he's too young, a susceptible victim, and somebody who has the opportunity to exploit that. So this would be maybe somebody who's close to him. It might be his lawyer, it might be his doctor, it might be a nurse who's taking care of him, it might be some other person who is important to his life. So somebody with the opportunity to take advantage of him. So a lot of cases apparently have been brought against people who were taking care of them. They not necessarily nurses, but if it's a nurse, you've got an easier case because it's against the ethics of nurses to take advantage of your patient. And these nurses are these people who were taking care of this elderly gentleman who needed some nurses in his house to take care of him because he was so old. In that case, these nurses would get very unusual gifts, very valuable gifts, not just a cheap ring, but a very expensive ring, or they'll be given an interest, the will will be rewritten and they'll inherit the house. And rather than the house going to the children of the man, it's going to this person who took care of them. So you have this opportunity. And there has to be a predisposition, that is, this person is shown that he wants to actually do this thing. He's got a predisposition to take advantage of it, and by an unusual and an unnatural transfer. So that's another element. So there are 5 elements there: susceptible victim, opportunity, predisposition, unnatural transfer. And so I don't write out the, on some of these I write out the examples, but on this one I did not write out the example. But examples are easily covered in terms of Groucho Marx and the Doris Duke Charitable Foundation. Now you have to prove the victim is susceptible. So that's a very important element. Now a person wanting to make an unnatural transfer, a person who doesn't want to give his inheritance to his children, and that would be Groucho Marx. He had one daughter. He had divorced her mother years ago and had disassociated himself with both the mother and the daughter for years. Wouldn't talk about them, wouldn't give them anything, thought very badly of them. And he was dying, and he had quite a bit of money, having been the famous actor and comedian that he was, and having been very good at investing his money. He had written her out of his will. And so at the hearing of the will, she shows up and challenges the will and demands that certain things that are not given in the will be included in the will. And these were certain jewelry that had been valuable jewelry that had been given to his favorite girl. And Groucho was a very rich man, so he had given this particular woman very valuable jewelry, hundreds of thousands of dollars on this jewelry. He called her the young chick, even though she was maybe in her 50s. For Groucho, since he was in his 90s, she was a young chick. And he was very fond of her, and it's not unusual for a man to do that. Not only that, now the question is, of course, whether or not he's susceptible to the wiles of this other younger woman. Okay, there is a story that was told in the courtroom about the fact that Groucho knew what he was doing, and the story was like this. It goes, Groucho had called all of his friends to have a dinner. He knew he was going to die soon. He said, I'm not going to be here much longer. Before I die, I want each of you to come and eat with me, and I'm going to put on a luscious dinner. It's going to be really very nice, just the best of everything, and you'll get whatever you want. And so everybody ate everything at once. He was very generous with his friends. And as they were leaving, the waiter came up to him and said, "Oh, Groucho, you forgot to leave me a tip." He looked right at the young man and he says, "I didn't leave you a tip because you were a lousy waiter, and that's why I didn't leave you a tip." So Groucho was no pushover. It was the point they were making, that Groucho, if he gave the woman some money, it's because he wanted to do it, not because she had somehow used undue influence to actually get it. So, yeah, so that's one case. Now, another case involves the Doris Duke Charitable Foundation. If you listen to the NPR, you will frequently hear that this program has been funded by the Doris Duke Foundation. The Doris Duke Foundation is actually run by her butler. When she died, she left all of her money to her butler, basically because, well, not all of her money. She left all of her money to a foundation, and she put in charge of the foundation at a high salary her butler. Butlers don't ordinarily run foundations. But he'd been running her household for years, and she always made every decision with him. And the argument was made by her surviving daughter, because she did have a daughter. Again, it's a case where she had disassociated herself with her daughter, who had married a man that she didn't approve of, and because she married a man she didn't approve of, she had cut her off and hadn't given her anything for years, hadn't talked to her for years, and she had written her out of her will and left all this to this charitable foundation, and to be, the foundation's gifts were going to be determined by this butler who's going to be running the foundation. and paid handsomely to do so. And so the daughter again challenged the will. But before she made out the will, she had had a team of psychiatrists and a couple of lawyers come to make sure that she would not be found to have been incompetent. She was under a lot of drugs, and that might indicate a person who had become incompetent and susceptible, and might have been a basis upon which to win it. She guarded against that by having these psychiatrists fill out forms, and they were available then to testify that they had found her to be competent, to know that even though she was heavily meditated, meditation's not the right word. Anyway, she was heavily under the influence of these drugs, they said, but she did know what she was doing, and therefore it was her act. This is what she wanted to do. She didn't want to leave money to her daughter, and so that held up too. So, so it's an easy kind of thing to do, to think that a person who's older who does these things might be doing it for the wrong reasons, might be being influenced. You can have these cases brought. I remember there was one case brought that stood up where it was determined that one of the sons had taken care of his father in his last illness, and the father had left everything to him, and they were able to successfully argue that he had used undue influence in getting everything to be given to him. And so it can work the other way, and but I think these are just cases that's not a famous case, but that's a case that actually does exist. So it's obviously that sometimes you could maybe win in that kind of cases. Now there are some questions that these are practice questions, like I said, that might help you with the exam. These are true-false questions. The first one, now you've heard the lectures, you should be able to answer these questions is the ideal. Of course, you're always attentive and you pick up everything on when you first hear it and can easily interpret things, right? A legal mistake can invalidate a contract, true or false. I'm not going to tell you the answers to these, but I'm giving you these questions. You might want to look, if you're not certain of the answer, you might want to look through the PowerPoints again, or listen to this talk again. The victim must justifiably and unreasonably rely upon the misrepresentation, true or false. Innocent misrepresentations, most jurisdictions allow for rescission if in these cases. So, is that true? Did you get that from the lecture, or is that just what you think? State courts found it reasonable to interpret an act of non-disclosure to be, in some cases, fraudulent. Okay, so the fifth question is, the test is whether the will of the victim was overcome. It is not an objective test. True or false? So each of those you look at, and if there's anything wrong in it, if one word is off, it's not the right word, watch out for that. Because I mean, that's where it is. I mean, we have a tendency when we read through these true-false questions, we know what something should be. We know what the test is. And if somebody, it's like on the previous, one of the previous tapes we talked about Noah's Ark. People, when you say, how many people did Moses take on his ark, will hear Noah, even though you don't say Noah. And the same thing happens when reading. People, when you read a true-false statement, will sometimes put in the correct word for a wrong word, a word that has been altered. That's why the knots that are sometimes put in to make a question false or to make it true will actually maybe not be seen by parties who know what the rule is and were familiar with the words in terms of a statement that didn't have the knot in it. So they will just kind of not see that knot, or it doesn't register in their brain. So that's what to watch out for. That's it for today. Thank you very much for coming, and I hope you all enjoyed the tape, and look forward to giving you another one. We spent a lot of time putting these tapes together, and we hope it's appreciated.